Hello, and welcome back. Today, we're looking at something that, well, it affects every single person in the United States, but you probably never notice it.
Not until you, or someone you know, tries to sue the federal government.
Exactly. We're talking about the U.S. Judiciary, specifically appeals, and how the government litigates.
It's a huge topic, but before we get started, if you could do us a quick favor and hit that like and subscribe button, it really helps us keep these discussions going.
Yes, please do. Okay, so let's get into this. When you picture a lawsuit, you probably think of two people, maybe a person versus a company.
Right. Fighting it out in front of a judge. One person wins, one loses, gavel bangs, it's over.
But when the federal government is the one being sued, the game is completely different.
That's the perfect way to put it. The government is not a typical litigant. It has something that scholars call institutional persistence.
Institutional persistence. So that means more resources, more lawyers.
It's more than that. I mean, yes, resources, but the big thing is time. And it has a structural advantage that's baked right into the court system.
Right. The sources we're using today really frame this as a war of attrition. The government uses the court hierarchy, procedural rules, and key players like the Solicitor General to turn disputes into these absolute marathons.
And winning, in the traditional sense, isn't always the main goal. Sometimes it's just about outlasting the challenger.
So today we're going to trace that path, from the lowest rungs of the ladder, through all the checkpoints of the lower courts, and all the way up to the Supreme Court's shadow docket.
Let's start with the battlefield itself. The courts.
The structure.
Right. Most people know the Supreme Court, but the federal judiciary is, it's a hierarchy. You have what are called Article III courts.
Pronounced Article 3. These are the ones set up by the Constitution.
Correct. So at the bottom, you have the 94 district courts. That's where trials happen, where facts are found.
Then what's next?
Above them, you have the 13 courts of appeals. Then at the very top, one Supreme Court.
And the judges in these Article 3 courts, they're the ones we usually hear about, appointed for life.
Appointed for life, their salaries are protected. They have a high degree of independence.
Which you'd think gives a challenger a fair shot, right? An independent judge.
In theory, yes. But this is where the government gets tactical. It understands something called the law of the circuit.
The law of the circuit. This is what they call the geographic lock, isn't it?
Exactly. The country is split into these regions or circuits. So if the Fifth Circuit Court of Appeals makes a ruling, that ruling is now the law for every single court in Texas, Louisiana, and Mississippi.
It's locked in for that region.
It is, but, and this is the key, it does not bind a court in New York or California.
So if the government loses a case in, say, the Ninth Circuit out west,
they might not appeal it to the Supreme Court right away. They might just let the issue percolate.
Let it percolate. So wait for other courts to weigh in.
Yes. They let different circuits come to different conclusions. They let a circuit split develop.
Ah, so they're almost manufacturing a disagreement among the courts. So the Supreme Court is more likely to take the case later, but on their terms.
It lets them pick their battles. But this structural advantage goes even deeper. We also have to talk about the Article I courts.
Article 1, pronounced like the number. These are the legislative courts that Congress creates.
Right. Think of the U.S. Tax Court or the Court of Appeals for Veterans Claims. The judges here are different.
I
They don't have life tenure.
Okay, I saw that in the sources. Magistrate judges get 8 years. Bankruptcy judges get 14.
Exactly. They serve fixed terms. And what this does strategically is it creates auxiliary buffers. They're like procedural checkpoints.
So you can't just go straight to a regular federal court.
Not for a tax dispute or a veteran's claim, no. You have to go through the specialized Article I court first.
It's a bottleneck.
It's a huge bottleneck. It forces the challenger to navigate all these extra layers of scrutiny before they ever see an independent Article III judge with life tenure.
So the system is designed with these outer defenses you have to fight through first.
Mm-hmm.
But even before you set foot in any courtroom, Article 1 or Article 3, there's another hurdle.
There is. It's the doctrine of exhaustion of administrative remedies.
Just the name sounds exhausting.
It's very well named. At its core, this is a timing rule. It just says that before you can sue the government in court, you have to climb the entire mandatory ladder of the agency's own internal appeals process first.
So if I have an issue with, say, a Social Security decision, I can't just file a lawsuit.
Nope. You have to file a complaint with the agency, wait for them to decide, appeal that decision internally, and on and on.
What's the strategic purpose for the government here?
Well, there are two. First, it prevents premature interruption of the agency's process. But second, and this is a really important part, it allows the agency to build the factual record on its own terms.
Because they control that whole internal process. They decide what evidence gets into the file.
Precisely. And by the time you do get to court, a judge is often required to give deference to that record.
The materials we looked at use the Prison Litigation Reform Act, the PLRA, as a really stark example of this. They called it a procedural straitjacket.
The PLRA is a perfect case study. Under that law, exhaustion is absolutely mandatory. It doesn't matter if the prison's internal grievance system is incredibly slow.
Or even if the agency can't give you what you're asking for.
Doesn't matter. You still have to go through the whole process. You have to tick that box. If you don't, your lawsuit gets dismissed immediately.
And that brings up the catch-22 with habeas corpus petitions. This was for prisoners who are challenging their detention.
Right. Yes, usually state prisoners trying to get a federal court to hear their case. The rule is you have to exhaust all your claims in state court first.
Yep.
But let's say a prisoner files what's called a mixed petition.
Meaning it has some claims that are exhausted and some that aren't.
Right. And a federal court generally can't hear it. The petitioner is totally stuck.
So what are their options?
They either have to drop the unexhausted claims, which means they give up those arguments forever, or they have to go back to state court to finish the process.
But all the while, the clock is ticking on the statute of limitations for their federal case.
Exactly. It just becomes another way the passage of time itself becomes a weapon for the government.
So let's say you're that rare challenger. You've got this stamina, you've exhausted your remedies, you've fought through the Article 1 and Article 3 courts. Now you're trying to get to the Supreme Court.
And standing at the door is the gatekeeper, the Solicitor General.
The 10th Justice. That's what the sources call this person. That's a pretty powerful nickname.
It really reflects the office's unique role. The Solicitor General, or the OSG, represents the entire federal government before the Supreme Court. And, well, statistically, they're just playing a different sport than everyone else.
The numbers are incredible. For you or me, or even a huge company, the odds of getting the Supreme Court to hear your case are, what, 1 or 2%?
A tiny fraction. But when the Solicitor General asks the court to hear a case, that grant rate shoots up to around 70%.
70. That is a staggering advantage. How? Why do they win so often?
Selectivity. The OSG is extremely selective about what it appeals. An agency might lose in a lower court and want to appeal, but they can't.
They need permission.
They need the Solicitor General's permission, and the OSG says no most of the time. They only appeal maybe 5 to 15% of agency losses.
So they're just weeding out all the weak cases.
Exactly. They only bring the strongest arguments. This preserves their credibility and their status as a repeat player. The court trusts them not to waste its time.
And then there's this other thing, the CVSG, a call for the views of the Solicitor General.
Right. This is when the Supreme Court is looking at a case where the government isn't even involved. But the justices ask the Solicitor General, hey, what do you think we should do here?
And the court actually listens.
About 80% of the time, the court does whatever the Solicitor General recommends. It's a measure of the immense influence that office has.
And if this isn't just one person making a call, the sources described a really rigorous internal process. U.S. attorneys have to submit these detailed reports to the OSG before any appeal is authorized.
It's all about ensuring a single, unified national legal strategy. You can't have a prosecutor in Florida making an argument that undermines a prosecutor in Oregon. The OSG keeps the government's message consistent.
Okay, so the government is good at getting cases heard. But what happens when they lose a big one in a lower court? A judge says a new regulation is illegal. Does it just stop?
Almost never. This brings us to the whole idea of policy stability and the government's tools for managing the status quo. The very first thing they do after a loss is seek a stay pending appeal.
And a stay is just a pause button on the judge's order.
It is. It lets the government keep enforcing the challenged policy while the whole appeal process plays out. And to get it, they have to argue they'll suffer irreparable harm.
But their definition of harm is different, right? It's
Yeah.
not usually about losing money.
No, they argue institutional injury. They argue that simply being blocked from enforcing a law or having an agency's operations disrupted is a kind of harm that can never be fixed.
The sources brought up the case of Cobell v. Norton.
That's a great example. A court ordered the Department of the Interior to disconnect its computers from the internet over security risks. And the government's argument for a stay was that doing so would paralyze its financial management. They framed it as a threat to the functioning of government itself.
And they got the stay. This leads right into the shadow docket, a term we hear all the time now.
Formally, it's called the interim docket. These are emergency applications that are decided on incredibly short timelines, and often you just get an unsigned order. No explanation, just granted or denied.
And the government's use of this has exploded.
Historically, it was for true emergencies, like a death penalty stay, but the data shows a massive shift. The Trump II administration, for instance, filed something like 32 of these emergency requests in less than a single year.
That is a huge increase.
It is, and it lets them keep controversial policies in effect for months, sometimes years, while the regular litigation is just slowly grinding away in the lower courts.
So on the topic of controversial policies, let's talk about injunctions. It used to be that a single judge could issue a nationwide injunction and stop a policy everywhere.
Correct. Block it for everybody, not just the people who brought the lawsuit. That has changed. The sources point to a 2025 case, Trump v. Sasson.
What was the big ruling there?
The Supreme Court held that the Judiciary Act of 1789 generally limits court remedies to only the specific plaintiffs in that case.
So if I sue to stop a policy and win, the court can only stop the government from applying that policy to me.
That's it. It cannot protect other similarly situated people who weren't part of the lawsuit.
What does that mean for someone trying to challenge a government action?
It makes it so much harder and so much more expensive. It leads to what's called patchwork enforcement. The government can keep enforcing the policy against everyone else in the country. To stop it nationally, you'd have to file dozens of separate lawsuits.
Which takes a massive amount of time and money.
It just raises the logistical and financial burden on challengers enormously. The government might lose one case, but the damage to its policy is contained.
That really feels like a fundamental shift. The theme is delay, contain, and exhaust. But are there ever situations where the government can just say, you can't sue us at all?
Yes. These are what you might call the final shields. The first one is the political question doctrine.
The idea that some issues just aren't meant for courts to decide.
Exactly. The government will argue that an issue is textually committed by the Constitution to Congress or the president, think foreign policy or military decisions. If the court agrees, it will dismiss the case as not justiciable.
It's not a ruling on who is right or wrong. The court is just saying this isn't our job.
Right, it's an institutional screen. And the sources point out this is often a prudential decision. The court is just deciding it's wiser to stay out of it for the moment.
And if the courts won't stay out of it, Congress can make them.
That's the nuclear option. Jurisdiction stripping. Article 3 gives Congress the power to create exceptions to the Supreme Court's appellate jurisdiction.
So Congress could literally pass a law saying the courts are no longer allowed to hear a certain type of case.
Yes. They could, even for cases that are already pending. It's the ultimate exit ramp for the government if they feel a major loss is coming.
We've really covered a lot of ground here, and it feels like the deck is stacked pretty heavily.
Well, the system is fundamentally designed for stability. And, if any single lawsuit could bring the government to a halt, you'd have chaos. But that stability definitely comes at a cost for the individual challenger.
Let's quickly recap the three biggest obstacles we talked about.
Sure. First, there's mandatory exhaustion. You have to climb that whole administrative ladder before you even get to court.
Right.
Second, the structural bottleneck. Navigating the Article 1 courts and then the whole Article 3 hierarchy.
And
The battle for finality. Even if you win, the government uses stays, the shadow docket, and now limited injunctions to keep the policy going.
It really changes what winning even means. You can get a court to say you're right, but if the government can delay the impact of that for years, have you really won?
That is the central question.
And that leads us to our final thought for you. We tend to think of a court decision as the last word. The gavel bangs, it's final. But if the government can use all these loopholes, these stays, and these doctrines to indefinitely prolong a fight, is a court loss ever really the end for the state?
Or is litigation just another tool for governing?
It makes you rethink the whole power dynamic. Thank you for listening to this look into the machinery of government litigation.
Thank you. And please don't forget to like and subscribe if you found this useful.
We'll see you next time.